Fourth Amendment, P167 to 573. Dodge v. Woolsey, 1866, 18. Howe 331 at 348, United States v. Sprague, 282, U.S. 716, Hawk v. Smith, 253, U.S. 223, British Coal Corporation v. The King, 1935, AC 500 and Edwards vs. Attorney General for Canada, 1930, AC 124-136 referred to. The grant of power under Article 368 was plenary, unqualified and without any limitations except as to the special procedure to be followed, 603, 604, 632. The range of A.E. Dement was this Constitution, which meant all the provements of the Constitution. If any part of the Constitution was intended to be excluded from the operation of the power to amend it, would have normally found a place in or below Article 368 when the people, through the Constituent Assembly, granted the power to amend. They made no reservations in favor of the people. When the Constituent Assembly directed that amendments of the Constitution must be made by a prescribed method, they necessarily excluded CBCLF other method of amending the Constitution. The grant of power under Article C-44 Supreme Court Reports, 1973, subscr. 368 is plenary, unqualified and without any limitations except as to the spiel procedure to be followed. All provisions in a constitution must be conceded the same character, and it is not possible to say that one is more important and the other is less important. If the object of a constitution is orderly government and orderly change in accordance with the law, it must be conceded that all constitutions, whether flexible or rigid, must have the power to amend the Constitution to the same degree. The amending power in a rigid Constitution may therefore reach all provisions, whether important or unimportant, essential or non-essential, having regard to the object of providing an amendment clause in a modern Constitution. Amendment must stand for alteration or change in its provisions. That the was intended is clear from the wording of Article 368. The proviso to the article clearly implies that an amendment under the article seeks to make a change in the provisions of the Constitution. Having regard to the importance of the TM clause in our Constitution, an amendment plates changes in the provisions of the Constitution which are capable of being effected by adding, altering, or repealing them, as found necessary from time to time. Thus, so far as the wording of Article 368 itself is concurrenced, there is nothing in it which limits the power of amendment expressly or by necessary implication. Consequences of WRCCKLCS use of power are political in character with which the court is not concerned. Consequences may be considered in fixing the scope and ambit of a power where the text of the statute creating the power is unclear or ambiguous. Where it is clear and unambiguous, courts have to implement the same without regard to consequences good or bad, just or unjust. Poiranki 2 to 585, Edwards Vlizier, Southwestern Reporter, Vol 33, 1130, Livermore v. Wait 100 Duca Hintonboiti, Airparte Dillon, 262 Federal Reporter, 563 decided in 1920, Dillon v. Gloss, 65 Law, ADN, 94, Airparte. Mrs. D.C. Kirby, 103, or 6,000 KLT v. Core, 8 Arc 436, Downs Fairtree, City of Birmingham 198 Southern Reporter 331, Schneiderman VQ in United Sculptures of America 87 Law ED 1796, Road Elsand v. Palmaf 64 Law ED 946, Ullman v. United Sculptures 100 Law ED 511, Whitehill Velkins 19 Law ED 2D 228, State v. Fulton 124 NE 172, and Vacher's case, 1913, AC 107 referred to. Article 13-2 did not operate as an urpris limicultion on the amending power. Amendment of the Constitution is not law within T. Munentov Artide 13 Pinapi 91 632. The Constitution or its amendment is neither a law and force within the meaning of Article 13.1, continued under Article 372.1. Nor can it be regarded as a law made by the state within the meaning of Article 13-2. The bat under Article 13-2 is not merely against law, but a law made by the state. The definition of the word state includes all organs or agency one operating under the Constitution owing superior obligation to the Constitution. It would be therefore wrong to identify state in Article 13(2) with anything more than the instrumental created or adopted by the Constitution, and which are required to work in conformity with the Constitution by its very definition, a body or set of bodies, exercising sovereign constituent power, whether in a Bexable or in a CIPF constitution, is not a governmental organ owing supreme obligation to the Constitution. The body or bodies operate not under the Constitution but over the Constitution. They do know, while amending the Constitution, function governmental organs and therefore cannot be regarded as the stallo for the putting pose of Part 3 of the Constitution. If fundamental rights in Part 3 were amendable, nothing would have been near than to make a specific PNM non about it. Part XX, which dealt specifically with the subject amendment of